This is Barry Zalma on insurance. I'm an attorney who's retired from the practice of law and now spend my time as an insurance claims consultant, an expert witness, an author, and producer of these videos. Today it's a day to talk about defenses to tort claim. Information needed by every insurance claims adjuster, representative, and defense lawyer. There are two basic defenses to tort claims: comparative fault and assumption of the risk through intentional or unreasonable exposure to obvious damage if the tort claimed is one of an accident. When I was a young adjuster, most states allowed the defense of contributory negligence, where if the plaintiff was even a small percentage at fault, he or she recovered nothing. That defense is only available now in a very few states and has been replaced with the doctrine of comparative negligence. The California Supreme Court, finding that contributory negligence as a defense was harsh and that a person 99% responsible for another's injury could not or should not escape with an absolute defense. They decided that almost all accidents, all negligence torts, were the result of negligent actions, potentially of both parties. The California Supreme Court enunciated in a case called Lee versus Yellow Cab a system known as comparative negligence, where the jury was instructed to determine the percentage of responsibility attributable to both parties. Clearly, the California Supreme Court understood the importance of this decision because Ms. Lee's first name was Ga, and so this was really Lee versus Yellow Cab, and most of the defense lawyers and insurance companies in the state of California, once that case was decided, said, "Golly, you've done it to us, Supreme Court." In New Jersey, the state enacted a comparative negligence statute following the lead provided by the California Supreme Court. The Comparative Negligence Act and the Joint Tortfeasors Contribution Law comprise the statutory framework for the allocation of fault when multiple parties are alleged to have contributed to the plaintiff's harm. Under the Comparative Negligence Act, in negligence and strict liability actions in which the question of liability is in dispute, the trier of fact makes the following findings of fact. 1. The amount of damages which would be recoverable by the injured party, regardless of any consideration of negligence or fault, that is, the full value of the injured party's damage. And 2. The extent in the form of a percentage of each party's negligence or fault. The percentage of negligence or fault of each party shall be based on 100%, and the total of all percentages of negligence or fault of all the parties to a suit must be 100%. Therefore, the plaintiff, if found to be any percentage at fault, would have the total recovery reduced by that percentage. In practice, the Comparative Negligence Act required the fact finder to assign to each party on the verdict sheet a percentage of fault, with the percentages assigned to each party adding up to 100%. With the fact finder's task complete, the judge then was required to mold the judgment from the findings of fact made by the trier of fact, and if a defendant's fault is assessed at 60% or more, the plaintiff recovered the full amount of the awarded damages from the defendant alone. If the fact finder apportions less than 60% of fault to that defendant, the plaintiff may recover from that defendant only the percentage of the damages assessed against the defendant. In contrast to the jurisdictions where the doctrine of comparative negligence was adapted by statute, in Michigan, as in California, the decision to adopt comparative negligence was made by the judiciary. This distinction is elevated to one of great importance when questions of the applicability of the doctrine of comparative negligence are raised. In those jurisdictions where judicial adoption has taken place, the courts are not constrained by the limits placed upon the doctrine by statute or the rules of statutory construction. Michigan, for example, concluded, as did the Supreme Court of California, that comparative negligence should be applied in all common law tort actions sounding in negligence, where the defendant's misconduct falls short of being intentional. However, where the defendant intentionally commits a tort, comparative negligence is inapplicable. Another defense is that of assumption of risk. Primary assumption of risk generally absolves the defendant of a duty of care toward the plaintiff with regard to injury occurred in the course of a sporting or other activity covered by the doctrine. A person who voluntarily and knowingly exposes him or herself to obvious dangers is deemed to have assumed the risk of injury. It is not contributory negligence. It is more like consent to the act. The defendant's conduct involves certain dangers or risks which the plaintiff voluntarily accepts. Knowledge of the significance of the risk is an element of the defense. A subjective standard is applied to assumption of the risk in determining whether the plaintiff knows, understands, and appreciates the risk. An objective standard is applied to contributory negligence, and the plaintiff is required to have knowledge, understanding, and judgment of the standard reasonable person. Assumption of the risks operates as a defense against negligent conduct. A person could also expressly agree to assume the risk of another person's negligence, and such an agreement is valid unless it contravenes public policy. Examples include off-road motorcycle riding. In the case of a plaintiff who claims to be fully aware of the hazards of the conduct and voluntarily assumes all risks of injury, there can be no liability. These contracts can be entered into before the injury and are enforceable as a form of assumption of the risk. Spectators at athletic contests such as baseball games, hockey games, or auto racing will be found to have assumed the risk. However, there is no assumption of the risk when there is no actual knowledge of danger. The adjuster must be sure, in conducting a thorough investigation, to establish a plaintiff's knowledge of the activity that caused the injury. If the plaintiff was injured at a hockey game by a flying puck, the adjuster should find out if this was their first time attending a game or if the plaintiff was a regular attendee. To prove the defense, it is necessary to show that the plaintiff was harmed while participating in an activity like touch football or amateur hockey and claims that defendant is responsible for the harm. To establish the defense, the defendant must prove that the plaintiff, his conduct was entirely within the range of ordinary activity involved in the particular sport or activity that the plaintiff was harmed, and that the defendant's conduct, although a substantial factor in causing plaintiff's injury, it was not outside the normal activities expected in the sport, a risk of harm plaintiff accepted when he agreed to participate in the sport. The California Supreme Court considered the continued applicability of the assumption of the risk doctrine in light of the court's prior adoption of comparative fault principles. Specifically, the High Court distinguished between two different types of assumption of the risk. Primary assumption of the risk, those instances in which the assumption of risk doctrine embodies a legal conclusion that there is no duty on the part of the defendant to protect the plaintiff from a particular risk, and secondary assumption of the risk, those instances in which the defendant does owe a duty of care to the plaintiff, but the plaintiff knowingly encounters a risk of injury caused by the defendant's breach of duty. When applicable, primary assumption of the risk operates as a complete bar to the plaintiff's recovery. In contrast, secondary assumption of the risk is merged into the comparative fault scheme, and the trier of fact, in apportioning the loss resulting from the injury, may consider the relative responsibilities of the parties. A jury in a secondary assumption of the risk case would be entitled to take into consideration a plaintiff's voluntary action in choosing to engage in an unusually risky sport, in determining whether or not the plaintiff should properly bear some part of responsibility for the injuries he or she suffered. Another old defense is that of last clear chance, a violation, for instance, of safety laws or regulations. The defense of last clear chance is an exception to the defense of contributory or comparative negligence. Since 1975, it has been subsumed into the doctrine of comparative negligence in those states that apply comparative negligence. The last clear chance defense allows recovery in spite of the plaintiff's negligence if the defendant had the last clear chance to avoid injury. It requires a finding that 1, the plaintiff was negligent, 2, the defendant knew that the plaintiff was in such a situation of danger, 3, the defendant knew, or in the exercise of ordinary care should have known, that the plaintiff could not escape from such a situation, and 4, the defendant had the last clear chance to avoid the accident by exercising ordinary care. Another defense is the doctrine of avoidable consequences. This is a doctrine of good faith and fair dealing. The injured person need not make extraordinary efforts to do what is unreasonable or impracticable in his or her efforts to minimize damages. Reasonable diligence and ordinary care are all that are required to allow full recovery of all damages caused by the defendant's wrongful activity. If the injured person acts with such care and diligence as a person of ordinary prudence would under the circumstances, and his or her efforts to minimize damages are determined by the rules of common sense, good faith and fair dealing would require a finding of liability against the person who caused the injury. The doctrine of avoidable consequences, which include the principle of mitigation of damages, is a common law doctrine. There is no question that absent a contrary expression by a legislature, well-settled common law principles are not to be abolished by implication. The doctrine of avoidable consequences prevents parties from recovering damages that could have been avoided by reasonable effort. This doctrine of mitigation is designed not only to prevent and repair individual loss and injustice, but to protect and conserve the economic welfare and prosperity of the whole community. For example, the rule in North Carolina is that an injured plaintiff, whether his case be tort or contract, must exercise reasonable care and diligence to avoid or lessen the consequences of the defendant's wrong. If he fails to do so for any part of the loss incident to such a failure, no recovery can be had. Failure to minimize damages does not bar the remedy. It goes only to the amount of damages recoverable. This has not been a complete recitation of defenses to tort claims, but is a recitation of some of the major defenses. It was adapted from my book, Zalma on Insurance Claims, Part 105, Second Edition, which contains a recitation of almost every potential tort defense that exists. The book is available as part of the 10-volume Zalma on Insurance Claims treatise and is available from Amazon.com as both a Kindle book and a paperback. If you found this video to be interesting or useful to you and your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and blog postings. Thank you for your attention.